Hello, everyone, and welcome to today's briefing session around information sharing. My name's Martin Webster. I'm the Workforce Development Manager at Darlington Borough Council People Services, and I'm joined once again by Chris Ashford, Multi-Agency Safeguarding Trainer for Darlington. So I think we can all agree that information sharing is vital in terms of safeguarding of children, young people, and adults. Chris, can you explain to us in a second when I put the presentation up why we're highlighting information sharing and outline issues identified and also what we actually mean by information sharing? So I'll just share the presentation now and I'll hand over to Chris.
Thanks, Martin. Okay, do you want to flick to the next slide then, please? Okay, so why highlight information sharing? Well, I think we all know that information sharing is a recurring theme that's consistently identified in serious case reviews and safeguarding adult reviews, and is crucial for effective safeguarding of both children and adults with needs for care and support. Sharing of information can improve decision making to ensure the best outcomes are achieved. Next slide, please, Martin. So what issues have been identified in those serious case reviews and safeguarding adult reviews? So many reasons for not sharing information appropriately have been identified, including lack of time, assumptions that others are already aware, not thinking something is important, confusion on what can and should be shared, consent issues, and decisions being made in isolation. Failure to notify other agencies when services were withdrawing support or closing the case. Recording of information was not always factually accurate, relevant, or indeed up to date. Failure to share minutes, meetings with all involved, with the family, often only shared with those who attended the meeting. Use of professional language, which is not always understood by all. And lastly, a lack of use, where appropriate, of chronologies and genograms. So what is information sharing? So information sharing should take place in circumstances where there is a clear need for the exchange of information, and that's important. There are, of course, legal powers which permit agencies to do so. The information shared should be relevant and proportionate to the purpose concerned, and information sharing can take place in a number of ways. So it can be around disclosure. So an agency acknowledges that it possesses relevant data. It may make that data accessible to a requesting agency or individual, but of course retains ownership and responsibility. The sharing of information, in which agencies pool available data and maintain single service-based records. Exchange of information, in which one agency provides one or more other agencies with relevant data. Ownership and responsibility passes to the new agency, which may amend or update the record to meet further requirements. And reporting, an agency provides statistical data for an agreed reporting mechanism, which may be reported to local and national groups. So there are many forms as demonstrated there when we talk about information sharing.
Thanks, Chris. Can you also tell us about the legal basis for information sharing and outline the main areas for us?
Yeah, and the legal basis is certainly some of the challenges when we talk about information sharing. Some people are perhaps concerned that there is a data breach. Are they allowed to share information? And so when deciding whether to share personal data for the purposes of safeguarding, so raising a concern as an example, whether it be around an adult or indeed children, practitioners must first establish whether there is a legal basis to share the information. But as we will see, the laws in respect of sharing information are in no way a barrier when we are talking about safeguarding issues. The four main areas of law that relate to the disclosure and sharing of information are our common law duty of confidentiality, the Human Rights Act 1998, General Data Protection Regulation, sometimes referred to as GDPR, and the Data Protection Act 2018. So the Data Protection Act 2018 and GDPR as I said before, are not barriers to collating and sharing information. They provide a framework to ensure that personal information about living persons is shared appropriately. The common law duty of confidence and the Human Rights Act 1998 do not prevent the sharing of personal information. This can be because it is data subjects' interest for the information to be disclosed, or that public interest would justify the disclosure of the information. So when we look at the principles, principles set out below are intended to help practitioners working with children, young people and adults with needs for care and support, and indeed parents and carers, to share information between organisations. So we should always consider, when sharing information, information should be adequate for its purpose. Information should be of the right quality to ensure that it can be understood and relied upon. Of course, it should be relevant. Only information that is relevant to the purpose should be shared with those who need it. Limited. When taking decisions about what information to share, practitioners should first consider how much information needs to be released. Only sharing data that is adequate, relevant, and limited to what is necessary is a key principle of GDPR and data protection. And practitioners should consider the impact of disclosing information about the data subject and any third parties. Information must be proportionate to the need and level of risk. It should be accurate. Information should be accurate and up to date, clearly distinguish between fact and opinion. Again, this is a key principle of GDPR and the Data Protection Act. Of course, it should be timely. Information should be shared in a timely fashion to reduce the risk of missed opportunities, to offer support and protect children and adults at risk. Secure. Information should be shared securely, and practitioners must always follow their organisation's policies on security for handling personal information. And lastly, recording. Record. Information sharing decisions should be recorded, regardless of whether the decision is made to share or not. This record should include the rationale for your decision to share, what information has been shared, and with whom in line with the organisational procedures. If the decision is not to share, again, the reasons should be recorded why you have decided not to share this information. Article 8 of the European Convention on Human Rights gives everyone a right to respect for family life, home and correspondence. Authorities can only interfere with these rights if the practitioner is acting lawfully and pursuing a legitimate aim, including the protection of health and the rights of others, and the action is no more than is needed. So in line with what we said around GDPR, data protection, again, this is not a barrier where it is appropriate to share, where we have those safeguarding concerns. The implementation of the Data Protection Act 2018 GDPR broadened the scope of the legislation to incorporate the processing of personal data for safeguarding purposes within organisations. So this is very specific. Okay, this is a special category data which relates to personal information of subjects, which is especially sensitive and personal, the exposure of which could significantly impact the rights and freedoms of data subjects. So where practitioners need to share special category personal data, they should be aware that the Data Protection Act includes safeguarding of children and individuals at risk as a reason, a condition that allows you to share that information where appropriate without consent, and can be used for the purposes of protecting an individual from neglect or physical, mental or emotional harm, or protecting the physical, mental or emotional well-being of individuals. So again, that demonstrates this is not a barrier to information sharing for safeguarding purposes.
Thanks, Chris. So here in Darlington, our children's front door is called the Children's Initial Advice Team. Can you tell us about the team and about how information is shared?
Yeah, there have been some changes recently in respect of the children's front door or the children's initial advice team, either terminology. So effectively, there are two numbers now for sharing safeguarding information. The first number, which will be provided for you, 01325406252, is for professionals with new concerns. So if you have a new concern as a professional, in whatever capacity, you would contact that number. You are not required to fill out a concern form. It will be a discussion with a member of staff from the children's front door, which will be recorded. Okay. That record will then be shared with you as a professional, a record of that discussion and a record of the agreed actions, outcomes. There is an additional number, 01325406222, and that number is for members of the public, but also for professionals where it is not a new concern. Perhaps they are ringing for information, for a discussion, to contact a social worker. So you would contact that number in the first instance. We talked about consent, and again, I've said previously that is one of the big barriers, perhaps one of the issues. And so, advice from the children's initial advice team is that it is always good practice and the expectation that you would seek consent from parents, carers to share a concern. However, it is acknowledged that there are occasions when to do so would put a child at risk or undermine the investigation into a serious crime. So an example there may be where the parent carer is the alleged abuser, the abuse is significant, and you would consider that actually by speaking to parents, it would place a child at risk, or as it suggests, undermine an investigation into a serious crime. So in these instances, a call would be accepted without consent from the parents. Of course, the reasons for not seeking consent should be clearly stated when speaking with the children's initial advice team and recorded on your internal systems.
That's great. And
And
as
again,
mentioned,
just to the information I provided, we were talking about it there, the children's initial advice team, the numbers provided for the professional number, the public number, but there are opening times for the children's initial advice team. So the opening times, they are available between 8:30 and 5 p.m. Monday to Thursday. On a Friday, 8:30 to 4:30 p.m. Outside of those hours, it's the same process. You would contact the emergency duty team on 01642 524 552.
perfect. Thanks, Chris. So, from a safeguarding adults perspective, can you talk us through information sharing from a safeguarding adults side and explain Darlington's front door for adults for us?
Yeah, so if we start by speaking about consent and obtaining consent, and there are some key differences from consent from parents and carers for children and perhaps consent from adults when sharing a concern. And the Care Act 2014 is the statutory guidance for safeguarding adults. And what it tells us is that if we are considering sharing a concern, it is always best practice, where possible and appropriate, to seek that consent to share that concern for the adult. But we should always consider, actually, is the adult able to provide that consent? So perhaps the adult may lack capacity in our view. Yeah, so they are unable to understand the nature of the concern and indeed what you intend to do, who you intend to speak to, and why. So if there is a lack of capacity in our view, then we would share that concern without consent as a best interest decision. We should also consider, actually, as with children, would seeking that consent actually place the adult at further risk of harm? Indeed, would it place anybody at risk of harm, including ourselves? And if that's the case, then again, we would share without consent risk. We then look at where the adult perhaps has capacity and tells us very clearly that they do not wish us to share that information. They do not wish us to raise that concern. When would we share without consent? Well, in fact, under vital interest or public interest. And vital interest is described as where actually by not sharing that concern, although the person does not want us to share that concern, the adult themselves would be at risk of further significant harm. So we would act in what's termed a vital interest. Public interest is where the adult actually declines consent, but we believe there are other adults at risk. So again, we would share that because of risk to others, so public interest. So these are the reasons we would share without consent. The Care Act, before we move on, does tell us that if a person initially refuses consent or does not consent to information sharing, we should always have a conversation with that adult and explain why we feel it's necessary and attempt to gain that consent before moving on to vital interest or public interest. Okay. And so a different contact number for the adult's contact team, as it's termed. So if you have a concern around an adult at risk of abuse, so anyone over the age of 18 who has any care and support needs, you believe they are being abused or neglected or likely to be abused or neglected, and they are unable to protect themselves because of that care and support need, you should raise your concern, considering consent, of course, with the adults contact team on 01325 406 111. Again, there are set hours when the adults contact team are available, as with the children's team. Outside of those hours, you would contact the emergency duty team, and it is the same number as the children's initial advice team. So the emergency duty team again is 01642 524 552.
So really tragically as well, Chris, information sharing doesn't always happen effectively. And the image on the screen is of Daniel Palker. Can you explain what happened in Daniel's case?
Yeah, absolutely. There are many, many examples, and this was a single example, a serious case review into the unfortunate death of Daniel Palker. And before I talk a little bit about the case, I would encourage people to access, you can access a short film around Daniel's life and the circumstances around his death. So if you were to search on Daniel Palker, Ordinary World, there is a very comprehensive video there. I will say, if you are going to access that video, there is a health warning. It is very upsetting, but it's important for our learning. Okay, but in Daniel's case, Daniel was a 4-year-old boy who died as a result of abuse in 2012. And what we know from the serious case review was, although a number of agencies were involved in Daniel's life, specifically between November 2011 and March 2012, shortly before his death, there were numerous episodes in the education setting that Daniel attended where it is clear that opportunities were missed to share information and indeed consider cumulative harm in respect of Daniel, a reason for sharing that information. So in November of 2011, just some examples. Daniel, there is recording that tells us that Daniel was observed stealing food from other children. Mum was spoken to. She provided an explanation around a possible eating disorder, and that explanation was accepted by school and no further action was taken. In December of that year, the school health worker wanted to pursue it further but was unable to contact mother, and so simply sent out a letter, and there was no response to that. Concerns in December, significant concerns around non-attendance at school for Daniel. The education welfare officer visited mum, who actually gave an account that she wasn't taking Daniel to school because of her own illness. She was unwell. Again, this was recorded, but no further. This information wasn't shared outside of that setting. Again, moving through, we're now in January of 2012, and after the Christmas holidays, Daniel returned to school, and it was apparent that he'd lost a significant amount of weight over the Christmas holidays. And it is recorded that he was found to have secretly eaten half a birthday cake that had been brought in for a teacher. Again, this was recorded but not shared. So again, examples of when is it appropriate to share this information. And as part of the serious case review, a number of concerns were identified when staff were spoken to, which were not shared outside of the organisations. Occasions where there was bruising to eyes and a scratch to nose, severe mark to nose, black eye, all separate incidents, blood spots on a nose, bruise to a forehead, large bump to the left side of the face. They were all noticed, but again, information wasn't shared. None of this was shared with social care. In February of that year, Daniel was observed eating a pancake by a playground assistant. The pancake was covered in grit and mud, and he'd pulled it from a bin. Again, no further action, not shared. 28th of February that year, concerns over his appearance and the fact that he wasn't interacting with other children. Another example of information. And lastly, the child was seen eating a piece of fruit which he'd taken from a bin, and later ate play jelly that had been put out for the children. And again, another example where no further action was taken. And sadly, Daniel died as a result of abuse, neglect. So these are really classic examples of the importance of information sharing, and that information should have been shared. There's no doubts about that. Okay.
Thanks, Chris. Some real kind of lessons to be learned for all of us there, I think.
Yeah.
We've now got a safeguarding adults case study to look at. Can you take us through it and outline some of the learning points?
Yeah, again, many examples of safeguarding adults reviews that highlight lack of information sharing where it absolutely was appropriate. And in this case, we have Tammy. This is a local case for us. And Tammy had mental health problems. She visited her GP for a routine check on her medication. And while there, she mentioned that her partner is violent toward her. So the GP expressed concerns, but Tammy says there's nothing to worry about, and in any case, it's no wonder he hits her, as she is very annoying. The GP says that she probably isn't, and even if she is, that doesn't mean she deserves to be hit. Tammy says she doesn't want to talk about it anymore and doesn't want the GP to tell anyone. So there's an example. When we think back to our reasons for sharing without consent, the thought should have been around, well, actually, is this a case of, she's clearly said, I do not want this shared, but there are care and support needs. So an adult at risk by definition, and the GP perhaps should have been thinking, is this vital interest as a reason for sharing this concern, a risk of further significant harm? So the GP is mindful of his duty of confidentiality to the patient. He knows that Tammy has no children, and he does not think that she lacks capacity to make decisions about living with her partner. So he decides that it is her right to make the decision not to tell anyone about the violence, but he does make a note on her file about it. So again, it's our considerations about vital interest at that point, isn't it? The next time Tammy comes to the surgery, she sees a different doctor. This GP has not seen the note on Tammy's file about the disclosure. Tammy has a bruise on her face. She says she fell over and that her jaw is very painful. The GP sends her to the hospital for an x-ray, and it turns out that she has a broken jaw. She has treatment from the hospital. The hospital staff do not question Tammy's account of the cause of her injury. A few weeks later, Tammy calls the police. Her partner has cut her arm open with a knife and is threatening to kill her. So a very short scenario there, but if we think about information sharing in this case, we have the initial incident with the GP, and yes, it was recorded, but not shared at all, including other staff within the surgery. So the other member of staff wasn't aware, so wasn't able to actually say, well, actually, this increases the risk. She's then sent to a hospital that, again, is not aware of this information, and maybe as a result of that, they didn't pursue it further. So these are examples about information sharing, aren't they? And again, when is consent appropriate? When is it appropriate to override that lack of consent? Okay. So learning points from this: when deciding whether to share information against someone's wishes, and we've talked a lot about this, haven't we? Consider whether they have mental capacity to make the decision and can fully understand the possible consequences. If we feel that's not the case, then we look at a best interest decision, lack of capacity, so the best interest decision to share that information. Establish whether coercion or duress is involved. This may warrant sharing information without consent, of course. Inquire about the frequency and seriousness of the abuse, so more information gathering from the person. Use gentle persuasion, explain what help and or protection might be available. So if somebody's going to consent, clearly they need to have the information available to make that decision, and perhaps then they may consent to that information sharing. Talk to other safeguarding partners without disclosing identity in the first instance. So never be afraid, whether it be a safeguarding children concern or a safeguarding adult concern, never be afraid to pick up that phone and have a conversation. At that point, you may not need to disclose the person's identity, but discuss the circumstances, discuss consent, discuss the information you have. So you've always got that opportunity. And that's the clear message above any other. Never be afraid to pick up the phone and have that conversation. Make inquiries to establish whether the alleged abuser, perpetrator, has care and support needs or is a carer themselves. And lastly, follow up on your discussion or your disclosures. Once you've had that discussion or raised that concerns, of course, always follow up what has been the outcome for that adult or indeed children.
Okay, so the last part of today's briefing, can you outline for us the key things that staff need to do in terms of information sharing?
Yes, so lastly, remember, as we've said throughout this session, the Data Protection Act, the GDPR and the Human Rights Act are not barriers to justified information sharing, but provide a framework to ensure that personal information about living persons is shared appropriately. Always be open and honest with the person and their family where appropriate, of course, from the outset, about why, what, how, and with whom the information will or could be shared, and seek their consent, their agreement, unless it is unsafe or inappropriate to do so. Don't be afraid to seek advice from other practitioners if you are in any doubt about sharing the information concerned, without disclosing the identity of the individual where possible. Where possible, share the information with consent. We've looked at that. Yes, if it's appropriate, gain that consent. But under GDPR and Data Protection Act, you may share information without consent if, in your judgment, there is a lawful basis to do so, such as where safety may be at risk. You will need to base your judgment on the facts of the case. When you are sharing or requesting personal information from someone, be certain of the basis upon which you are doing so. Where you have consent, be mindful that an individual might not expect information to be shared. Be very clear about the reason for that consent and what you intend to do with that information. Always consider the safety and well-being of the child or adult. Base your information sharing decision on considerations of safety and well-being of the individual and others who may be affected by their actions. Necessary, proportionate, relevant, adequate, accurate, timely, and secure. That is the message. Ensure that the information you share is necessary for the purposes for which you are sharing it, is shared only with those people who need to have it, is accurate and up to date and is shared in a timely fashion and is shared securely. And lastly, as with any other decision, any other action, keep a record of your decision and the reasons for it, whether it is to share the information or not. If you decide to share, then record what you have shared, who you have shared it with, and for what purpose.
That's brilliant. Thanks, Chris. So for further information, you can contact Chris directly via email, as you can see there, chris.ashford@darlington.gov.uk. And you can see this presentation on the Workforce Development intranet pages or for wider distribution at the Darlington Safeguarding Partnership website. Thanks very much for your time today, Chris. Much appreciated.
Thank you very much, Martin.
Cheers all.